request the chair and speakers for session 2 to kindly take their respective seats as we begin the proceedings for the session on polygamy, personal choice, or patriarchal practice. The chair for this session is Professor Tahir Mahmood, Professor and Founder Chairman, Institute of Advanced Legal Studies, Amity University, Noida, Uttar Pradesh. The speakers are Professor Faizan Mustafa, Vice Chancellor, Chanakya National Law University, Patna; Professor Lizelle Calvino, Associate Professor, University of Zululand, South Africa. She will be joining us online. Dr. Theresia Wirastri, Assistant Professor, Faculty of Law, University, Indonesia; and Dr. Farhana Abdul Fateh, Senior Lecturer, Gender Studies Program, Universiti Malaya, Malaysia. I request the chair to please take the proceedings forward.
It's okay now? Yes. Yeah. Can everybody hear me? So, welcome all of you to this session, which I have been compelled to preside over. And among my speakers of the day, afternoon, Faizan has been known to me for more than half a century. So I don't know how to introduce him. He is one of the top post scholars of law in the country at present. And the two great ladies come from two countries which are dearest to me. And I have been associated with many universities in both the countries, both Indonesia and Malaysia. So from Indonesia is Dr. Wirastri, and from Malaysia, Farhana. Yeah. And there is a professor from South Africa who I understand will be attending online. This session is on polygamy, and I would rather want to hear the other speakers on it rather than speaking myself. But I can, to begin with, tell you that polygamy here in this country, not polygamy only, but even bigamy, which means two spouses, is absolutely prohibited, both under the law of civil marriages and under all religion-based personal laws of the country, except the Muslims. But for the Muslims also, it has been greatly restricted by legislation and by judicial decisions, but it hasn't been totally prohibited until now, which is a lacuna in the law of the country. There have been many judicial decisions of the Supreme Court of India and several high courts which restrict the practice of polygamy. We had an Indian penal code enacted in 1860, which had a provision for bigamy, but it said that bigamy will be an offense only if it is void under the law applicable. Now, under every law applicable, bigamy is void, so that provision applies to everybody except the Muslims, because under Muslim law, traditional Muslim law, bigamy is not void. Bigamous marriage is not void. The Indian Penal Code has been repealed and replaced by a new law in 2023. But it reproduces exactly the provision of polygamy as it was under the Indian Penal Code. They could have easily deleted this clause from the provision that it will be an offense only if it is void under the law applicable. This could have been deleted under the new law, but it has not been deleted. So until now, the position is that under the penal code, under the penal law, bigamy is an offense only if it is a bigamous marriage is void under the law applicable to a particular couple. Under the personal laws, it is void and penal for everybody except the Muslims. Let's begin with the session. The first speaker is Faizan. I would request him to kindly speak. And let me warn all the speakers that I already am very strict, and now I have been told by the organizer I have to be very strict about the time. So
what is the time, sir? For each speaker, 10 minutes? 15
Yes, 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 yes. Maximum.
Many years ago, there was a conference organized by Sir in the Indian Law Institute, and after presenting my paper, I went to him and I thanked him. And Sir was very unhappy with my thanks. मेरे कंधे पे हाथ रख के he said, बड़ों से दुआ लेते हैं, शुक्रिया नहीं अदा करते. It's extremely difficult to speak in his presence, but recalling that conversation which we had, I have come just to take his wishes. The whole country and the whole subcontinent know of family law in India and in the subcontinent because of writings which Professor Tahir Mahmood has written. He is the living legend and the greatest living family law expert in this part of Asia, and one of the leading exponents of family law in the entire world. Now, since I have a time constraint, I'm going to make a slightly different argument. Of course, this is not, I think, open to even discussion that polygamy is bad and oppressive and must be prohibited and banned. I think the issue is long settled, even though there have been two opinions about this, to which I will make some passing reference. But lately, there is some new thinking on the whole question of polygamy, even in United States. It has been not allowed because it was claimed to be the part of one's religious practice, particularly Mormons or by Muslims in India. But the new concerns is it part of privacy or due process after the Lawrence judgment? My interest in this new position is because of some of the laws which we have in India, apparently in favor of women, but they have had the opposite effect. Just to give quickly examples, look at NRC in Assam. Now, you have child marriages. Young girls married in another village have no document to prove, and Assam NRC required that you have to prove who is your father, whether his name is there in the list, whether your grandfather's name is there in the electoral roll, etc. So many of these women, young women who are now married in another village, had no document. And of course, since they are below 18 or 21, their name was not entered in the electoral roll where they were there at that point of time. Similarly, in some of the states for local bodies elections, we have come up with laws that if you have more than 2 children, you are not allowed to contest election. Supreme Court has upheld that law, and the effect is that if your first child is a daughter, then the second child must be a male child, leading to a lot of illegal abortions and in many cases even divorces. Then we somehow imagine that there is a problem that people are systematically, even though the government's position in Lok Sabha has been that there is nothing like called love jihad, but we came up with law to protect, so to say, the Hindu women, the majority in communities women, or SC/ST or Dalit women, and come up with very stringent punishment for such kind of conversions and marriages, even though word love jihad has not been used in any law. But all these laws basically undermine the agency of women, that they cannot make right choices about their spouses. And similarly about the triple talaq law, which we recently criminalized. So there is no effect because law says that triple divorce does not result in dissolution of marriage. But lately there are studies done in Hyderabad and in Delhi that husbands have become very, very cruel with their wives, and they force them to take khula, and the domestic violence cases have gone up. Therefore, the question today which I want to put before each one of you is that yes, marriage is both a public and private institution. It does involve an individual's personal decision to make a lifelong commitment to another, but there are laws which govern this choice. Who can marry and when can you marry? There have been prohibitions of having more than one wife, to which Professor Mahmood rightly made a reference. Even when we came up with a new penal code called Bharatiya Nyaya Sanhita, this was something which escaped their attention. There was an opportunity to make it applicable even for Muslims. Both me as well as Professor Tahir Mahmood very strongly feel about it, that this exemption should not be there for Muslims. But we should also be conscious of the fact, as American sociologists J.H. Locke and J.A. Patterson have said, that where polygamy lacked legal sanction, it frequently existed in more or less illegal form of concubinage. And that is a question whether mere criminalization of polygamy is good enough. That is the question which I am addressing. And what has happened in India when we prohibited it under the Hindu Marriage Act? Are Hindu women in any way now in a better position today? In all religions, you had polygamy. There are references in Bible. Abraham had it, David had it, Solomon had it. In pre-Islamic Arabia, you had it. In ancient India, you had it. Raja Dashrath, father of Lord Ram, had 3 wives. You in modern times got laws in Bombay, 1946, in Madras, 1949, and then finally, as Professor Mahmood rightly said, in 1955. But even bringing that law was not easy. Today, when a debate happens in India about Uniform Civil Code, we forget that what happened to Hindu Code Bill. So Swami Karpati Maharaj, who headed the committee against the Hindu Code Bill, opposed ban on polygamy in 1955, which Nehru was bringing, and quoted Yagvanalakke, which I am quoting here. If the wife is habitual drunkard, a confirmed invalid, a cunning, a barren, or a spendthrift woman, if she is bitter-tongued, if she has got only daughters and no son, if she hates her husband, then the husband can marry a second wife while the first one is living. Nobody would go by this kind of thing today. But this is how, when the law was being made in India. As you look at England, statute of James I made it punishable, and then you have a judgment, well-known Heidi versus Heidi, 1866, where marriage was considered to be between one man and one woman, no homosexual marriage. And then in United States, you got bigamy laws when President Lincoln brought it in 1862. But there was opposition for Mormons, and finally Wilford Woodruff issued a manifesto in 1890 officially denouncing polygamy, which facilitated attainment of statehood for Utah. So what was the argument in United States? You have Chief Justice saying that it is injurious to public morals, saying that it is akin to human sacrifice or even sati, though in both you don't have a consent. In polygamy, you have a consent. In the 1856 presidential election, Republican campaign was that we are going to fight against 2 relics of barbarism, polygamy and slavery. And the kind of arguments which are given in favor of polygamy, both in the United States as well as in India when we were bringing reforms, are like this. So Janet Benin, an anthropologist, said that polygamy enables men to satisfy their biological predisposition to have multiple sex partners and offers sense of security and a kind of sisterhood to modern women. And I am sure Sir must have had several very close interactions with the greatest or one of the greatest Hindu law expert, Duncan Derrett, who himself said that it is argued that carefully regulated polygamy, that is plural marriages in case of infertility, mental instability of wife, and other cases where the good sense and humanity of husband and his family requires from divorcing her or annulling marriage where she is impotent or very sick, would only be in accord with traditional Hindu sentiments. This is what Derrett wrote in a critique of modern Hindu law. Even one of the greatest Hindu law exponent, P.V. Kane, favored some kind of polygamy. I am not going in this debate, but similar arguments were made when in 1955 Hindu Code Bill was introduced. The only question is that she may fall sick and she may not be fertile enough and she may become lunatic. But all these conditions also apply to him. He can also fall sick. He can also become lunatic. But that argument was never made in our parliament. Of course, there were people who argued in favor of polygamy and treated it as a relic of past and said that it is very, very oppressive. There are some modern writers also, very interestingly, who also are worried more about inequality, that men are allowed to marry, women are not allowed to marry, like Martha, who says that, okay, if women are also allowed, it is okay. Now, the whole question is that polygamy cannot be justified on any ground. And broadly, the reasons are that it proclaims inferior status of the feminine sex. If a woman is an equal partner in a marriage, then it's fine. But if she is not an equal partner, then it is outrageous to permit any kind of polygamy. There were some enlightened people who favored abolition, but today there are researches which say the ill effects. So they were making a logical argument, but now you have empirical evidence, and empirical evidence tell us that polygamous household is oppressive, is stifling and unequal in comparison to monogamy. It has many harmful effects, particularly towards women and children. There are studies which say that women in polygamous relationship enjoy less marital satisfaction, have more problematic mother-child relationship. When they become pregnant, all the time they worry that now husband is going to pay more attention to other wives, and the children of polygamous marriages don't do well. And even men who are in polygamous marriages become alcoholic and adopt drinking. And there are chances of having sexual diseases as well. Women feel powerless in such kind of marriages. And by and large, one has to say that there is hardly anything positive which comes out of empirical evidences that such marriages are good. And therefore, the standard argument is that polygamy subordinates women and fails to treat women as equal with men. Now, what should we do? All these laws have been there. I'm not going in a debate whether Islam permits it. Sir made a reference that it is only for Muslims that it is allowed. The liberal Muslim scholars who just read the text of the Quran, they say that the condition of doing justice is very strict. God is very clear that you won't be able to do justice, and therefore monogamy is a rule and polygamy has to be a rare exception. And that's why several Muslim countries have restricted it. Some have succeeded, some have not succeeded. The best example comes from Tunisia, who said that other than Prophet, nobody could do justice. But why these kind of laws are not effective? Let us talk of India. We have applied this remedy for Hindu women. We propose that this should definitely be extended to all others. But the requirement of law to punish a man for bigamy is stringent. You have to prove two valid marriages and therefore two solemnization of marriages. And many Hindu intelligent husbands have escaped punishment because in the second marriage, instead of 7 steps around sacred fire, they just took 4 or 5. There are cases where admission by the husband that I have taken a second wife has not been treated as solemnization, and husband has been allowed to go scot-free. There are cases where there was a court marriage. They say court marriage does not prove that there was solemnization of marriage. And as a result, we have a very bad condition that women at times are not able to prove their first marriage, at times not able to prove second marriage. You have judgments from Supreme Court, including one from Justice Karju, saying that the second Hindu wife is a mistress, not entitled to any maintenance. And that is why one should look at how this law has worked. So in 1974, about 20 years after this law was made, a survey was done, and it was found that polygamy was slightly higher amongst Hindus than Muslims, for whom it was allowed. For Adivasis, that is scheduled tribes, it was 15%. For Hindus, 5.8%. For Jains, 6.7%. Buddhists, 7.9%. And Muslims, 5.6%. Now, in terms of numbers, if you convert it into numbers, if you had 1 crore Hindu men having more than one wife, you had just about 12 lakh Muslim men, because their number is more. Hindus are about 80% of our population. Then Malika B. Mistry in 1993 did a research, and she also found that the trend is almost similar. And the latest figures are, this is National Family Health Survey, that polygamy has decreased amongst all communities from 1.9 to 1.4%. In northeastern states of Meghalaya and Tripura, it is 6.1% and 2% respectively. Polygamy is more prominent in states like Bihar, where I am working right now, Jharkhand, West Bengal, and Odisha. So if you are backward and poorer, you will have higher rates of polygamy. Scheduled tribes demonstrate the highest prevalence of polygamy, though the trend is decreasing from 3.1%, it is about 1.5% now. Christians have 2.1%, Muslims have 1.9%, Hindus have now 1.3%. Now, what is a solution? And the two new solutions which are being talked about, with which I will end, is this. One is that they are arguing that since you allow any number of live-in partners today, so one need not marry anyone. If live-in is allowed, then legal marriage will not be there. Is allowing live-in instead of a legal marriage, which will involve some kind of obligations and rights, is a better option. There are scholars who don't have a firm opinion on that, but they are looking at this question very clearly. 2, if we believe in right of privacy and autonomy of individual, even our Supreme Court has not recognized, unfortunately, same-sex marriages. This is considered to be one of the most regressive judgments of former Chief Justice of India, Justice Chandrachud. But there are countries where same-sex marriages are
Faizan, you are exceeding your time.
Just sir, last 30 seconds, sir. So now the question is that there are people who are saying, but in United States also, maybe by 2040, this is Brad Wilcox, who is heading the US National Marriage Project, that there is increasingly libertarian or laissez-faire view that many younger zombies in America take towards sex, marriage, and family life. And therefore, they say this is probably a question of privacy, not a freedom of religion thing. The other is the postmodern polygamy, which is called polyamory, which may be a homosexual union instead of heterosexual union, there will be multiple partners, but there will be a consent. And the third is a very interesting suggestion by Davis, who says that we need to look at company law or a business law. So it is a part of freedom of contract doctrine now, rather than sacramental monogamy. And they say that let there be a kind of a contract, some kind of limited liability companies kind of marriage relationship, where everything is written down, and then it is decided whether the partners want to exit, if they want to exit, on what terms and conditions. Thank you very much.
Yeah, thank you, Faizan. It's now the turn of our colleague from South Asia, Professor Calvino. Is he online? Yes, if he's in line, we may request him to speak.
Calvino, please share your screen with us and your PPT.
Visible.
We have it on the screen. Please go ahead with your presentation.
Welcome.
10 to 12 minutes, please. Thank you.
Good morning, ladies and gentlemen. Thank you very much for this opportunity. I'm just putting on my screen to show that I'm not AI generated, but I am going to switch off my screen just for technical purposes and also just to save the Wi-Fi. Ladies and gentlemen, yes, I have listened to my colleague, and most certainly polygamy is an extremely contentious issue to discuss. And obviously from where I come from South Africa, the position is very different, as in the case of India. And I heard the comments made by my colleague earlier. Today, what I would like to do is I would like to present on polygamy, specifically and its interaction with personal choice, cultural tradition, and patriarchal structures, which is something very relevant in South Africa. The focus of this presentation is therefore to explore women's agency in polygamous unions, not as simplistic binary of choice versus oppression, but rather as a negotiation with instructional constraints. I will therefore look at comparative examples with some countries in Africa, very briefly touch on India, as it has already been addressed, as well as in context of Western society and jurisdictions. Lastly, I will introduce the concept of agency under constraint as a lens and a possible solution to understanding these dynamics. I'm just trying to move my slide. There we go. My apologies. So polygamy is a complex and a contested marital institution, often defined on cultural and religious grounds, yet widely critiqued for reinforcing patriarchal power. This study investigates how women navigate polygamous unions across diverse legal, cultural, and economic contexts. Using a comparative feminist social legal lens, I intend that the study will examine the gap between formal legal protection and women's lived experiences. Central to this analysis is the concept that women exercise agency, though their choices are frequently constrained by social norms, economic dependency, and family hierarchies. The problem statement is therefore, although women may appear to consent to polygamy and polygamous unions, but the consent is often shaped, limited, or coerced by structural forces such as patriarchy, religion, economy, social expectations, etc., as mentioned by my previous colleague. The problem question, therefore, is, do women that consent to polygamous unions consent meaningfully, specifically considering their circumstances and their conditions? The objective of this research is threefold. Firstly, to analyze the legal frameworks that govern polygamy in various jurisdictions. Secondly, to understand how law, culture, and gendered powered interests influence women's experiences in terms of polygamous unions. And thirdly, to provide actionable policy and legal recommendations that promote women autonomy while respecting cultural diversity. The methodological application that I've applied in terms of my research is multidisciplinary approach, looking at doctoral legal analysis, comparative law, as well as looking at it from a feminist social legal theory. The approach therefore explains an examination of polygamy from a legal, cultural, and a gender-specific and perspective simultaneously. We have doctoral legal analysis. It examines statutes, constitutional provisions, and in terms of South African law, specifically the Recognition of Customary Marriages Act, which basically recognizes and gives legal recognition to polygamous marriages in South Africa. In addition, landmark cases of our constitutional court, such as the case of Gumede versus President and Mayelane versus Ngonyama, where the issue of autonomy of wives were underlined and underpinned. This highlights how law frames polygamy and protects or, for that matter, limits women's rights. In terms of comparative analysis, mention will be made of Nigeria, Mali, India, Western context, etc. It will investigate tensions between religious freedom, gender equality, and statutory protection. And from a feminist social legal analysis, it will apply agency theory and intersectionality to situate women's lived experiences within structural constraints. By applying this, it will reveal the gap between the law on the books and the law in action. From a historical perspective, as already indicated by some of my colleagues, it has been a long practice across cultures. Polygamy, especially polygyny, has existed for millennia in many societies, and several economic, political, and social purposes and tribal systems has basically brought about this practice. In agrarian society specifically, a man's ability to support multiple wives reflected wealth, social standing, and political influence. From a religious standpoint, as indicated already, major religions, including Islam, historically sanctioned polygamy. It also integrated into customary practices in many African and Asian societies. And I think this is where my contribution might put a little bit of a different perspective on polygamy. Polygamy persists in parts of sub-Saharan Africa, Middle East, and South Asia, although, as already indicated, it is declining globally. The contemporary debate, however, is that the historical practices intersect with modern concerns of constitutional equality, human rights, and gender justice. And by understanding historical depth is essential for analyzing women's agency, legal framework, and cultural norms today. Policies must therefore balance respect for cultural and religious tradition with protection of women's rights. Looking at the scholarly debates, many feminist scholars view polygamy as a manifestation of patriarchal domination, reinforcing male privilege and female subordination. It is often linked to gender inequality, limited autonomy, and structured power imbalances in family law. Emerging feminists and anthropological perspectives also emphasizes women's strategic agency within polygamous systems. Women may choose polygamous unions for social security, economic stability, or emotional support, thereby demonstrating agency under constraint rather than passive victimhood. Scholars also debate whether legal prohibition or regulation of polygamy better protects or promotes women's rights. Legal bans, for example, in the Western states often fail to address informal or religious unions. Legal recognition can therefore provide protection but also entrench patriarchy, which is basically also touched on by my previous speaker. International feminist scholars also argue that polygamy conflicts with principles and constitutional equality norms, therefore caution that imposing Western human rights frameworks may inadvertently disregard local cultural meanings of marriage, which is very important in terms of South African legislation. The central scholarly divide remains. Should polygamy be abolished in the name of equality, or should it be reformed to protect women within it? And I think this is really the issue that we are grasping with today. The middle path advanced in my study, which is agency under constraint, might just breach these opposing positions. Feminist social legal lens, furthermore, persists that positions of women as active participants in rather than passive subjects of cultural and legal systems draws on intersectional feminism to show how gender, class, religion, and culture interact to influence women's agency. It distinguishes between law in theory and law in practice, recognizing that formal rights might not necessarily translate into substantive equity. Looking at it from a goal perspective, the goal of this paper is to develop a context-sensitive understanding of women's autonomy in polygamous unions, and hopefully to inform legal and policy reforms that enhance women's substantive agency rather than imposing uniform cultural or legal models. Looking from a South African perspective, and I know this might be a little bit different from what my fellow speakers will be addressing, South Africa, prior to the Recognition of Customary Marriages Act, did not criminalize polygamy, but it did give recognition to polygamous marriages. The Recognition of Customary Marriages Act specifically gives legal recognition of polygamous marriages under the Act, specifically Section 52 thereof. What is very important in terms of South African legislation is the Constitution of 1996, which guarantees equality, dignity, and cultural and religious freedom. This creates a constitutional balancing act between gender equality and respect for cultural practices. Traditional interpretations, like I've mentioned before, as in the case of Gumede, as well as the case of Mayeladlene, strengthens women's rights in polygamous customary marriages. In these cases, specifically, the court adverted and re-emphasized that the consent of the wife is required in polygamous marriages. A further dimension is the proposed marriage bill of South Africa, which will basically give recognition to polygamous marriages. The aim is to provide an inclusive legal framework that allows South Africa's international obligations to eliminate discrimination. Despite progressive legal recognition, however, inequalities persist due to patriarchal economic dependence and lack of awareness. The challenge, therefore, remains to translate formal equality into substantive empowerment for women in polygamous unions. Looking at comparative perspectives, and I'm going to move very quickly in this regard, because some of it's already been touched on by my previous speaker. Nigeria, for example, where polygamy is legally recognized under customary and Islamic law, but not under civil law. You're looking at Mali, where polygamous marriages are, for example, recognized. Other African countries, for example, Senegal, also make provision for a mixed system where couples may choose monogamous or polygamous marriages. The regional trends, however, across these jurisdictions is that there is a shared struggle to reconcile constitutional equality with cultural legitimacy. There's a formal recognition that offers women some legal protection, but patriarchal structures and economic vulnerability persists. Therefore, reform efforts increasingly emphasizes education, women economic empowerment, and community-level advancement along legal challenges. I'm not going to touch on the Western perspectives because the Western perspectives were already addressed by my previous speaker, as well as the situation in India. What I am going to do, however, is just touch on the key comparative analysis. From the discussions, it's clear that polygamy in Africa are formally recognized in law. In India, it depends very much on your religious affiliation, and in Western countries, very much criminalized polygamy. The cultural and religious legitimacies, though, in Africa and in Indian societies is deeply rooted in tradition and religion, and it is viewed as legitimate within those moral frameworks. Gender rights perspective provides legal recognition in Africa and in India, offers partial protection, but does not disseminate patriarchy. In addition to that, in plural legal contexts, women may exercise agency under constraint, entering polygamy for economic security or social legitimacy. From a constitutional perspective, all systems grapple with reconciling cultural pluralism and constitutional equality. The answer might be agency under constraints. It describes how women exercise choice and decision-making power within restrictive social, legal, and economic structures. It basically refers to women's actions are content-dependent, negotiating within family hierarchy, customary expectations, as well as realities.
Professor
Also
Calvino,
looking at constraint factors of patriarchal norms, economic dependency, limited legal protection, and social stigmas restricted to women.
Professor,
Yes.
if you may conclude your slides.
Thank you. In terms of recommendations, is to adopt a unified pluralistic marriage framework, strengthen women's legal protection, enhance access to justice,
I'm afraid
promote
you have to
social
close
economic.
your presentation. You have to close it now. You have exceeded your time. Sorry for that.
Okay, can I conclude?
Just half a minute.
Thank you. Polygamy is a complex social legal phenomenon. Exercise strategic agency, but the autonomy is often constrained by economic dependency. And I will just leave you with the following words. True gender justice in polygamous unions is not achieved through legal recognition alone, but through a transformative approach that empowers women to exercise meaningful agency within the realities of culture, law, and economy, thereby recognizing their strategies, resilience, and choices as central to shaping equitable marital futures. I thank you.
Thank you, Liz, you have given us a bird's eye view of international perspective on polygamy. Thank you very much. It's now the turn of our Indonesian friend. Please.
Good afternoon, everyone, esteemed scholars, and friends. So, my name is Theresia Dyah Wirastri, and this afternoon I would like to share some stories from Indonesia. It's the case of unregistered polygamous marriages. So I would underline that these cases are unregistered ones. So in Indonesia, we have legal regulations that if someone wants to perform polygamy, then he has to ask for permission from the religious courts. It means the Islamic courts, and also permissions from the existing wives. Okay, before I begin my presentation, I would like to convey my gratitude to the committee and also to the organizers for inviting us all here. Thank you so much. Okay, I will start briefly with the historical aspects of polygamy in Indonesia. So, in my country, the issues of polygamy has been the object of serious political contestation since the colonial era to date. So it is actually surprising how little we know about how people practice it. In most Indonesian Muslim circles, polygamy is considered religiously valid and therefore allowed. Since the 1974 marriage law in Indonesia, it made polygamous marriages conditional on certain legal requirements. A large portion of polygamous marriage remain unregistered. Surprisingly, little research has been conducted on practices of unregistered polygamy in Indonesia and the reason women and men have to start such union, regardless the social stigma and insecure legal status of the parties involved in informal marriages. What is meant with socially stigmatized is that many Indonesians regard polygamy as a shameful act that needed to be kept secret. But sooner or later, the secret of polygamy usually became public and invited negative reactions. These negative reactions usually directed to the additional wives and sometimes even to their first wives. Based on the research which was conducted with fellow scholars in Indonesia, first wives are mostly blamed for not being able to perform their role and obligation as a good wife, which is to serve their husband well and to bear children for their husband. This construction of a good wife who has to be healthy, to serve or support her husband, and to bear children is written in the Indonesia marriage law and the Indonesia compilations of Islamic law. Additional wives are often spoken as someone who takes the honey from the bee. However, many of them also portray as someone who destroys the harmony of someone else's marriages. Socially and politically, the practice has been controversial, and this is reflected in the debate between the pros and the cons of polygamy in Indonesia, which has been ever present in the Indonesian history. In the 1970s, the Indonesian lawmakers took a middle ground position in the debate by allowing but limiting polygamy. Okay, so I would like to speak a little bit about the legality of marriage. So according to the marriage law, a marriage is legal if it is conducted according to the party's religion or belief, and B, it is registered according to the statutory provisions. However, this definition is a bit tricky because in reality, we could have two interpretations. Firstly, someone's marriage is legal if it is conducted according to the party's religion or belief and it is being registered. Secondly, people can't interpret it as someone's marriage is legal if it is conducted according to the party's religion or belief or it is being registered to the state. The second interpretation denies the compulsory nature of marriage registration, thus refuses any interventions from the state in the holy contract of marriage. Islamic parties have refused the state's intervention in marriage affairs long before the enactment of the marriage law. There already were regulations on marriage registration during the colonial period. However, those regulations were implemented locally and varied from region to region in the Netherlands Indies. Any attempts from the colonial government to regulate marriage affairs nationally, including prohibition on polygamy or minimum age to get married, were rejected.
Theresia, you have 1 minute only.
Oh, 1 minute left?
Only 1 minute.
Okay. Oh, okay. So I actually collected some stories from, okay. So what makes it unregistered polygamous marriages? First, legal requirements are not met. Second, it is kept secret from the public or even their family. And third, it has the disadvantageous legal position for unregistered wives and their children. And these are the stories of 3 women with their different background. I mean, I can give the PowerPoints and you can read it. But maybe I just briefly say.
I think we can finish it now. Thank you very much.
Oh.
Thanks, Farhana. Farhana, 9 minutes.
I'll time myself, if you don't mind as well. I have my timer here. Okay, can I? Okay. All right, so very good day to everyone, to the honorable guests, esteemed panelists, and our respected members of the audience. First of all, I don't know how I can follow up from the previous speakers because I am not a legal scholar. So I'll be coming at this from a very different perspective, which I'll get into it later. Okay, so when speaking about polygamy, I'll be speaking from a Malaysian perspective. So it is again an Islamic perspective. So I'll be looking at the topic from, like I said, a different angle. So first of all, just an introduction. So basically in Malaysia, polygamous marriages are legally recognized and permissible. However, the practice is regulated under several provisions under the Islamic Family Law Act 1984. So married Muslim men in Malaysia who wish to undertake in polygamy must obtain consent from the Sharia court. So they have to fulfill the following 4 conditions. So number 1, the proposed marriage is just or necessary. So they can cite health reasons that prevent, them from having conjugal relations. Number 2, the applicant has the means to support his wives and dependents, including would-be dependents. Number 3, the applicant must prove his ability to accord equal treatment to all his wives as stipulated under the Sharia law. And number 4, prove that the proposed polygynous marriage will not result in legal harm to the existing wife or wives. So you can probably determine from this that it's quite hard to actually fulfill all of these conditions. And it was reported that more than 1/3 of applications were rejected by the Sharia court in Malaysia last year alone. So what do some of these men who feel like they must take on another wife, okay, what do? So they basically travel to southern Thailand, right? Specifically in districts like Songkhla, Narathiwat, because here, there's a lot of Muslim communities there. The law isn't as lax, isn't as rigid in Malaysia, so they get married there. Okay, so it was reported last year that 60% out of 300 Malaysian couples who travel to southern Thailand to marry are polygamous. Okay, so this arrangement, although it is valid in the eyes of religion, it can actually leave the parties, especially the wives, existing and future children, vulnerable to abuse as they are not protected by Malaysia's legal provisions, especially if the newlyweds did not register the marriage upon their return to Malaysia. Okay, so now I'll go back to where I'm going to be coming from when talking about this topic. So I will be framing it through a language and discourse analytical lens. So this is the framework with which I am most familiar because I was trained as an applied linguist. So my worldview is very much shaped around the questions of how do people speak about this topic? What language, terminology, words, or slang do they use to converse about it? So to most people, this may appear as an inelegant or maybe trivial way of looking at the subject, certainly not as sophisticated as legal jargons and religious edicts, but to a discourse analyst, paying attention to what people say and how they say about things can reveal the deep-seated beliefs and underlying ideologies that legitimize such norms and practices. So to that end, my presentation centers around 3 key points, basically revolving around, this is a statistic to show you the decline in how many polygamous marriages applications were rejected in Malaysia last year, okay? So it's getting stricter. So more trips to Southern Thailand, boost Thailand economy. Okay, so the golden umbrella. So unpacking the discourse of payung emas, which is what we call it in Malay, this is a term commonly used among Malay-speaking Muslim communities in Malaysia, Indonesia, Singapore, and Brunei to basically refer to the reward given to Muslim women who permit, again, a very highly contentious word, their husbands to marry another wife. So basically, this is a bestowment of a divine gift to honor them for their piety and loyalty. So this terminology is largely absent in academic literature. However, it remains very pervasive in social media and popular culture. So you will see it being regurgitated in the form of TikToks, okay, in TV shows, in films, etc. So this is two of the examples. Basically, you whisper to your wife, smile if you want to get a golden umbrella. And if the wife doesn't know what it means and she smiles, okay, that means I get the permission to take on another wife. And then this one is again best friends being silly with each other about being, co-wives. Okay, spoiler alert. Okay, so let's unpack the golden umbrella, all right? So if you picture an umbrella and the connotation it carries, so the literal umbrella protects the bearer against the elements, but what is it actually protecting the married woman against? All right, so several interpretations are possible, and they all point to the ideal of a dutiful, protective wife and mother. So for one, the umbrella protects the woman and her family from aib, or shame. So it's indeed shameful if the husband, father, man is found entangling himself with another woman not bound to him in marriage. So to protect the sanctity of the familial unit and to prevent the husband from engaging in zina or adultery, the woman is compelled to acquiesce to the arrangement of polygamy. So in terms of gold, it is indeed something precious and rewarding. So for a dutiful wife's sacrifice, gold is what awaits her in the afterlife. But gold is also a valuable commodity, one that is sheltered against devaluation. So even though the woman now shares her husband with another, her value as his wife and rightful companion remains protected. So the addition of golden enhances the imagery, suggesting not just any form of protection, but an esteemed precious reward that awaits women who sacrifice their own desires for a greater perceived good, as dictated by supposedly religious narratives. So this metaphorical language reveals how deeply embedded cultural constraints shape societal expectations of women, reinforcing traditional roles that may govern their autonomy and direct their actions toward compliance with polygamous practices.
Wind up, please.
No, I have 4 minutes, according to my timer. Sorry, sir. I traveled so far. Okay, can I, Madam Abni, proceed? Okay. So basically, we talk a lot about how women are being forced into this, but there's also some kind of alternative framings that say, they can actually be willing players in the game. So in 2024, a couple in Malaysia made the local news when it was reported that the man had actually taken on another wife, actually at the request of his first wife. Okay, so this picture was shared all over social media. So this is not really an expected or a typical scene when you talk about polygamy. Okay, so it paints an alternative discourse. But in recent years, there's been a challenge to this Payung Emas discourse. All right. So in 2016, the website of the Office of the Mufti of the Federal Territory posted their response to the question, is the hadith or sayings attributed to the Prophet Muhammad, peace be upon him, regarding gold umbrella sahih or authentic? And so this is a portion of their answer. Regarding gold umbrella, there is no mention of it in the Quran or a hadith. This means gold umbrella is just a fabrication and an untrue perspective. So it is true that there are verses of the Quran which mention marriage and the relationship between husband and wife. However, there is no mention of gold umbrella. So basically, they posted the same to their social media and they got a lot of reaction. So most women were jubilant and relieved, like, oh God, thank God, like, this has been clarified. But some men were like, what is this? They responded with such incredulity and derision. So they said things like, this post should be entered into a fiction contest because they don't believe it. And then some others will be like, oh, why not a gold durian? People love durian more than umbrella, which is a very typical Malaysian response. But some men actually say, hey, thank you, because I grew up thinking that this was really a valid hadith. So, and it has caused so much damage. So it's good that we actually stopped this, because imagine if it had been going on for years and years and years, the trauma it can continue to cause. And women also say that this was something that has been used by husbands to pacify their wives, to get them to permit them to get a second wife. And since then, there's been a lot of scholars who have also questioned the Payung Emas. This is one, Ustazah Asma Harun, who's very, very kind of like stern in her saying, don't ever relate the golden umbrella to polygamy ever again. And according to like Prof. Faizan said, she was also saying that whatever is permitted for the Prophet is not necessarily, freely permitted to people, like us.
Sorry for the discourtesy, but
I'll conclude.
You have to close it now.
Okay, yes, I'll conclude. So one of the ways that we can talk about like alternative discourses is through media representation. And this is one way we're doing it. Maybe we can talk about more about this, because as a person who does research on Muslim women in media, the framing of a non-veiled woman versus a veiled woman when it comes to co-wives is also very problematic, but we can take that into the break. Thank you very much.
Thank you, Farhana. I'm afraid for the question and answers that we have only 4 minutes, and we can take 2 short questions. And those who want to put questions, they should put only questions. Don't make it a new presentation. And just put a question to the speakers. Any questions? Yeah, please.
Theresia, what was your conclusion?
I think the question was surrounding whether how should people perceive polygamy in Indonesia. So, in one hand, it seems like a ambivalence. Oh, sorry.
You can come back to it later.
Is there any conflict of different school of Islamic law in Malaya legal court, like Hanfi school of law and Malki school of law, as we Indian Muslim have to face? Is there any conflict in interpretation of different school of law?
Okay, thank you for the question. So first of all, I'm not a legal or religious scholar, but so I can probably answer this maybe from my layman perspective of what I know about Malaysia. We follow the Shafi'i mazhab, and we're quite strict, or not strict, but we're we remain in that school of thought. I mean, I think in the legal system they may converse about it, but in terms of how we talk about the legal provisions, I believe that it follows the that. I don't know if that answers your question.
One more question, last.
Okay, I'm Dr. Amina, and just so I'll keep my question brief. So criminalization of triple talaq that was discussed. It has, of course, made it unconstitutional, but somehow, there's a very low level of literacy among Muslim women. So it has not really translated into any transformation in terms of the lived realities of Muslim women. So again, it has led to this, halala and other things. So while it could be an act of deterrent in terms of, Muslim men, and there is 2019, there is a prison also, but how has it really, it has not really impacted the lived realities of Muslim women. So I would like you to respond to that.
Be short.
Yes, sir. Thank you very much.
But we are speaking about polygamy, not
No,
triple
but
talaq.
she asked about that. No,
It was part of the discussion.
I got it. She's coming from the question, when we make pro-women law, we end up harming them rather than favoring them. Now, the triple talaq law, because Supreme Court said, if you give instant divorce, it is void. So marriage is not terminated, it is not dissolved. So there is no harm done. For criminal law to create a liability, there has to be a harm. So it's just a kind of an abuse. Now, what our law does now, if somebody uses that 3 dirty words, he is sent to jail for 3 years. The question is, will it help the wife? The man from the jail can give a divorce which is valid in law, where he would pronounce it one each time for 3 months. So by the time he comes out of jail, the marriage will not survive. This is one. 2, since many Muslim men know that they may be punished for this crime, they don't want to give triple divorce, but they force them to take khula. Sir is on record and has written on this, that this is absurd that you say that you waive your dawar and you waive this and that. Whatever is hers. Yet many Muslim men are beating their wives and forcing them to demand khula so that they are not punished under the triple divorce law.
Thank you, Faizan, for your reply. I have to close the session. I have to forego my privilege of making some concluding remarks. There is no time.
No, can I just give, please, we know,
No,
I know
I'm
the
sorry,
organizers are doing time
I'm
management.
sorry, I've been asked to close exactly at 6:30.
Mr. Chair,
4:31.
please allow me to speak.
Okay, half a minute.
Yes. So I would like to give 2 minutes to Theresia to speak. And after that, Chair, I also want to give you a minute and a half to conclude. We also want to hear what you want to say about
but
it.
there's no time for that.
No, but
so
we are giving you time. We are giving you time.
Yes.
4 more
So,
minutes. 4 more minutes.
We are
please.
cancelling the tea break.
Yes,
and
yes,
so
we
we'll
are
get
cancelling the
Lisa
tea
time
break.
to
Okay.
make-
Yes.
When
Theresia,
Faizan
please,
finished,
please.
I was going to remind him, I'm sure he knows, he was speaking about various states and what is the position of polygamy in various states. I just wanted to remind him that in Goa, one of our states, where everybody knows that the Portuguese civil code is in force, but the Portuguese civil code applies to the Hindus subject to a local law, the Hindu Usages Decree of 1880. And it says in so many words that if a married woman does not give birth to a male child within 5 years of marriage, the husband will have a right to have another wife. This is modern India, and the Hindu Marriage Act doesn't apply in Goa. It is local law which applies to the Hindu. Many factories. The legal constraints on polygamy, in my opinion, are a total failure in the country. No law preventing polygamy or criminalizing polygamy or punishing people for polygamy has succeeded in totally eradicating polygamy from the country. So we have to think of something
Theresia?
other than legal sanctions and punishments.
Yes. Theresia, would you like to speak from the chair, or would you like to come to the lectern?
You can speak.
I think I'll just use my PowerPoint.
Okay, please come.
Okay, so since I'm a social legal scholar, but first of all, thank you so much for the time. I just want in case of Indonesia, I would like to underline how non-compliance to marriage law in terms of unregistered polygamous marriages also shows like a patterns of ambivalences experiences by the women involved. So the three cases that were actually presented in the PowerPoint, all the three women considered that marriage registration to constitute full recognition as a wife. Indeed, Article 2 of the marriage law stipulates that a marriage will be considered legal if it is conducted according to the parties' religion or belief and registered to the state. Muslims are obligated to register their marriages to the Office of Religious Affairs, while people with other religion have to register their marriages to the Civil Registration Office. On the implementation level, it appears that many people do not automatically obey the law and register their marriages. The law in the books and the law in action, as previously mentioned by Professor in South Africa, are clearly two different things, and people may avoid the law without consequences. Although there are no official figures available for the prevalence of unregistered marriages, let alone unregistered polygamy, the practice still appeared to be widespread, especially for the second marriages that follow informal divorces, the latter being divorces that have not been sanctioned by the court. And one last section, a special feature of unregistered polygamous marriages in Indonesia is that they are concluded while from a legal perspective, the parties should have known that an existing marriage will perform a legal obstacle for the marriage. The existing marriage is not only a legal ground for the court to, upon request of an interested party, declare a second marriage void. Such marriage may be considered to constitute a criminal act. Article 279 of the Indonesian Criminal Code stipulates that 1. Every person who solemnizes a marriage despite that he knew that an existing marriage or existing marriages from a legal obstacle to do so may face a maximum penalty of 5 years incarceration. Additionally, it also stipulates that when someone deliberately obscures a situation as mentioned in point 1 to the other party, this person will face a penalty of maximum 7 years. In practice, this means that both the person solemnizing an unregistered polygamous marriages and a husband who keeps a second marriage secret to his first wife can be brought to the criminal justice system. This happens only sporadically because a criminal process depends on the willingness of the prosecutor to press charges, a willingness which often lacks. So the question in Indonesia these days is that how should we perceive practice of polygamy? Is it a continuation of a social practice, or is actually an opposition to the state's law? The answer, I will say that, reflecting on the unregistered polygamous marriages that we have, mostly it's both. So it is a continuation of social practices that often happen inside the community, and it's also signing a struggling from especially the Islamic Party of Indonesia to say that the state should stop intervening cases of marriage in their citizens' life. And that's why we often also say that it is indeed a opposition to the Indonesian state's marriage law. Okay, that's my conclusion. Thank you.
Thank you for the session. Thank you, speakers, and thank you, the chair. So as we are running late of time, so we'll proceed with the next session. In the meantime, please feel free to bring tea or coffee into the hall. And thank you for your understanding.